Welcome to Solving Citizen Legal Encounters. All right, today we have a Solving Citizen that want to use the script. And I think he actually learned the script from someone in the jail because I have two hearings on him. The first hearing, he wasn't really saying much, but it's good to know what's going on with his case. And then the second hearing is when he unleashed the script. Well, he tried to. Let's go.
In the Nisqually jail, sir, good morning. What is your name, please?
Say it again.
What is your name, please?
Loveless Herman Tucker II. Y'all have down Langston Arrington Copeland, or not Langston Arrington Copeland. You got Langston Copeland Arrington. I don't know who that is.
Lotus Herman Tucker II.
Understood. So, sir, I understand that your legal name is Langston Arrington Copeland and your date of birth?
Incorrect.
Eh?
What is your correct name?
Langston Daniel Arrington Copeland.
Langston Daniel Arrington Copeland.
Yes. Your
Thank
paperwork
you.
says that you have something against Langston Copeland Arrington. I don't know who that is.
Understood. And Mr. Arrington Copeland, I show that your date of birth is December 30th, 1988. Is that accurate?
Yeah, for that documentation.
Thank you very much. Mr. Arrington Copeland, you are before the court in two different cases this morning. 26L000032 is before the court for a pretrial conference. Case number 26L000304 is before the court for an arraignment. In the arraignment matter, you have been charged by the city of Lakewood with one count of domestic violence court order violation. Mr. Larson, it appears that your law firm is the attorney of record on the pretrial conference matter. Are you prepared to proceed with the arraignment at this time?
I am, Your Honor. And first addressing the issue of appointment on the new arraignment matter ending in 304. I do believe that Mr. Arrington will qualify. He's been appointed to our firm on a prior case, Your Honor. And I don't believe his financial situation has changed. So we would ask for appointment on the new arraignment matter as well, Your Honor.
All right, thank you. Based upon that information, the court will appoint the Horwath law offices to represent Mr. Arrington Copeland on the arraignment matter ending in 0304. The court will order the execution of a promissory note. However, that is subject to waiver once the court receives and reviews the eligibility screening sheet, once that is filed by Mr. Larson following today's hearing.
Thank you, Your Honor. Mr. Arrington Copeland has received the city's criminal complaint. Defense will waive a formal reading and ask that the court enter a plea of not guilty today. Defense would stipulate to probable cause for the purposes of today's hearing only. Furthermore, Your Honor, I've gone over Mr. Arrington Copeland's rights at arraignment, and I do not believe that Mr. Arrington Copeland has any questions for court or counsel at this time.
Thank you. Mr. Arrington Copeland, on the arraignment matter, based on the request of your attorney, the court is going to waive formal reading of the criminal complaint, find that there is probable cause to support the filing of the charge, and enter a plea of not guilty for you at this time. The court is next going to hear from the prosecutor regarding his recommendation for pretrial conditions of release, and then I will give Mr. Larson an opportunity to respond on your behalf. Mr. Tuninga.
And Your Honor, the city does have concerns based on the fact that this is not only the first protection order violation, but the second protection order violation that Mr. Arrington Copeland is alleged to have, or Mr. Copeland Arrington rather, is alleged to have violated. We have the pretrial matter, which has a protection order violation, date of violation, January 6th, 2026. And now, just a little over a month later, date of violation, February 18th, 2026. So the city does have some concerns for the safety of the victim as well, based on the fact that this violation was where the defendant was found on the premises of the protected party's house. So the city is requesting bail in this case. City is requesting $5,000 bail on each of the cause numbers for the defendant to abide by all active no contact orders, and for the defendant to have no criminal law violations.
Mr. Larson.
Your Honor, defense would object to any imposition of bail here and would note that Mr. Arrington Copeland really has a very limited criminal history, Your Honor. It looks like his last prior conviction, which I will note was for a driving offense, was in the year 2020, and there's a few more. There's a couple more in 2018 and 2020 as well, Your Honor, but also driving related. Very limited criminal history here, Your Honor. I've been able to chat with Mr. Arrington Copeland today regarding these protection orders. I think, you know, it's one of those situations, Your Honor, where there's a little bit of, there shouldn't be, but there was a little bit of ambiguity with regards to what this protection order prohibited him from doing. You know, we've talked about steps he can take to address the underlying protection order. I believe it's out of Pierce County Superior Court. So Mr. Arrington Copeland knows what he needs to be doing now or not doing, and we would ask for his release on his personal recognizance based on that very limited criminal history, Your Honor.
Thank you, Mr. Larson. Mr. Tuaninga, I am unable to bring up the probable cause statement in case number ending in 0304. Are you able to provide me a summary of the allegations?
Yes, Your Honor. Let me just make sure I have the right file open here.
Oh, it's okay. I'll just let Mr. Tuaninga summarize it for me. I looked in Visual Vault and I didn't see it.
You need to swear me under oath, Your Honor?
No.
Okay.
As long as it's stemming from the probable cause statement that I assume that your office has already filed with the court. I just haven't seen it.
On 2/18/26, at approximately 17:39 hours, officer was working uniform patrol for City of Lakewood. Several officers were dispatched to 8314 Pine Street South regarding an in-progress order violation. The reporting party, Bailey Ivory L., called in stating that her ex-boyfriend, Arrington Copeland Langston, was inside her residence refusing to leave. A records check did show a valid /served protection order, which listed Bailey as a petitioner and Arrington as a respondent. The order was issued out of Superior Court. South Sound 911 records confirm the order and warrant.
Thank you very much. The court is going to go ahead and impose bail as requested by the prosecution in this matter. I think that's appropriate for the following reasons. Mr. Arrington Copeland appeared before the court alleged to have violated the very same order that is before the court in case number ending in 034 today. It was before the court for arraignment on January 7th, 2026 in case number ending in 0032. At that time, I think the court was very clear with Mr. Arrington Copeland that he was being released on his personal recognizance because of the lack of criminal history on condition that he comply fully with the terms and conditions of the domestic violence no contact order that had been issued by the Pierce County Superior Court. Looks like that order was issued on January 5th, so the day before, or 2 days before. Now, unfortunately, I have before me a couple of matters that have occurred since then. First of all, Mr. Arrington Copeland failed to appear for his first pretrial conference in case number ending in 0032 on February 5th, resulting in the issuance of a warrant in the amount of $10,000 cash or bond. That warrant remained outstanding until he was arrested yesterday based on probable cause that has just been recited by the prosecutor, suggesting that there is probable cause to believe that not only was Mr. Arrington Copeland on warrant status on case number ending in 0032, but that he had violated the Pierce County Superior Court's protection order yet again in the new case under 0304. The court is also noting that the warrant that Mr. Arrington Copeland was directed to address at his arraignment on January 7th in Kent Municipal Court remains outstanding and does not appear that any efforts have been undertaken to deal with that warrant. And furthermore, there is a new bench warrant that has been issued by the Tacoma Municipal Court on a case from January of this year as well that apparently, according to JAVS, is presently outstanding. The court does take into consideration that Mr. Arrington Copeland has very minimal prior criminal history, and that is to his credit. The problem is that the court at this point doesn't have any confidence that he is going to comply with the orders of the Pierce County Superior Court or this court. And so the court will grant the request of the prosecution to set bail on these matters.
Here we go.
Mr. Arrington Copeland, I would not at this point, because anything you say is being recorded.
I'm
I
fine
don't
with
want
that.
you, I don't want you to accidentally say something that the
I don't
prosecution
care.
can.
I have something to say. Because
Well, Mr. Arrington
that doesn't
Copeland,
matter.
I'm not gonna stop you, but I want you to be aware of the risk that you're taking.
That's fine. So I just have a question. I have
Sure.
one question.
Okay?
How am I supposed to make court dates if I can't get any paperwork? This woman locked me out of my own apartment. I could not get any paperwork. I had no idea when my court date was or any of that stuff. I literally am just now getting any information. I've been locked out, standing outside in the cold for the last 3 weeks.
Mr. Arrington Copeland, I don't doubt that.
On top of the fact that I don't want to mess your name up. So Seth right here just told you that the violation order is against Copeland Arrington. That's not my name.
I understand that. Yeah, I think we have established that your name is Langston Daniel Arrington Copeland. I'm not disputing any of what you told the court. The problem is that the Pierce County Superior Court issued an order barring you from having any contact with the residents that you just mentioned on January 5th of this year. And now the prosecution here in the city of Lakewood, where that apartment is located,
And they
has
told
filed
me,
two separate
they
cases
told me that I had to
accusing you
go
of
through,
violating that order.
they told me that I had to go through certain processes, and they told me they told me that I couldn't even fill out the paperwork because the name's
Mr.
in
Arrington Copeland, I'm going to advise that you refrain from talking anymore on the record. Like the judge said, like Judge Lewis indicated, everything is being recorded. Anything you say can and will be used against you.
And Your Honor, one other issue that Mr. Arrington Copeland may be aware of, my office has had contact with the alleged victim in this case. The alleged victim has let us know that she has his wallet, and we were wondering how we could best effectively provide that to Mr. Arrington Copeland, because we want to make sure he gets his personal effects as well as, it sounds like, his court dates.
Certainly. And that's typically something that I leave to the attorneys for the parties. I know in the past in these situations, through representatives of the prosecutor's office, arrangements have been made to provide those personal effects to defense counsel. I've also seen situations where arrangements have been made for the protected party to deliver that wallet or those documents to the Lakewood Police Department, so that the restrained party can then go to the Lakewood Police Department and obtain those personal effects without violating the order.
I just thought it best to bring it up, especially with what Mr. Arrington Copeland.
Certainly, yeah.
Thank you,
And I'll let you and Mr. Larson discuss that, but those are two options that I've seen utilized by attorneys in this court previously.
And Your Honor, because the protection order is issued out of Pierce County, this court would not be in a position to authorize any sort of civil standby. Is that correct?
That is absolutely correct. Yeah, what I can, yeah, you're spot on, Mr. Larson. What I can do is, based on the information that Mr. Tuanenga has just given me about the protected party wanting to return personal effects to Mr. Arrington Copeland, those are a couple of methods that I've seen used by attorneys in the past. But as far as getting an authorized civil standby, you are absolutely correct. The only court that has the authority to issue that amendment or exception to the no contact order is the court that issued it. And that was Judge Farmer with the Pierce County Superior Court in Tacoma. That is the only court that can authorize a civil standby exception to their order.
Understood. Thank you.
Mr. Larson, my intention is, as with the preceding matter, given that the court has imposed bail, is to set this matter for next Wednesday in the event that Mr. Arrington Copeland remains in custody. I'm also inclined to set this matter for an out-of-custody pretrial conference in the event that he is released from custody. The court's inclination is to set that for March 26th at 2 p.m. Is there any objection to that course of action?
No objection, Your Honor.
All right. All right, Mr. Arrington Copeland, that will conclude your hearings in these two matters. If you are still in custody, we're going to see you next Wednesday, which is the next available court date that we have for the in custody matters there in Nisqually. If you bail out, your next court date will be March 26th at 1 p.m. here at the Lakewood Municipal Court. If you do secure your release regarding your personal belongings, the paperwork that you mentioned earlier, give Mr. Larson or one of his colleagues a call and let them assist you in setting up a way to get those materials from that apartment so that you don't have to run the risk of putting yourself in a position where you could be accused again of violating the order, okay? All right, the court has signed that order. Mr. Arrington Copeland, that will conclude your hearing, sir. You can go ahead and let the officer know that your hearing is done.
How much is bail?
I'm sorry?
How much is bail? You ain't giving
$10,000 cash or bond.
1,000?
10,000.
10,000?
$10,000 cash or bond.
So what's that, $1,000? All right.
Yes, sir.
Hey, Larson. I need you to figure out how to get in contact with me in here because I got paperwork I need to file against 2 or 3 people.
And Mr. Larson, Mr. Tuaninga, I have been informed by the court clerk that the remaining matter on our Nisqually calendar, Ms. Schaefer, has again refused to appear for court proceedings. She refused yesterday. Matter was set over to today. She has now refused 2 consecutive days. We have scheduled 3 review matters, 1 pretrial conference, and an arraignment. The court's inclination at this point is to set the matter on the Nisqually calendar for tomorrow, with instructions to officers at the Nisqually jail to utilize reasonable force to attempt to compel Ms. Schaefer's attendance at that hearing tomorrow. Is there any objection from either party?
No objection, Your Honor.
No objection from defense, Your Honor.
Thank you. That will be the order of the court. Is there anything further from either attorney before the court is at recess?
Nothing from the city, Your Honor.
It's amazing to me in the beginning how he used a totally different name. And then when the judge presented him with the name that should be his name, he agreed to it other than some rearranging of the name. We're ready to go to the next hearing. And we're going to see how he acts in this hearing. It's going to be a little bit different. Let's go.
And good morning in the Nisqually jail. Can you hear me?
Indeed.
What is your name, please?
My true name or the name you have on file?
Either one.
True name, Lovis Herman Tucker II. Name on file, Langston D. Arrington Copeland, hyphenated.
I'm still wondering where the other name comes from.
Understood. Okay. Mr. Arrington Copeland, do you mind having a seat so that I can see you?
May I ask what the difference is? I was in court the other day and they wasn't asked to sit down.
Okay, that's fine. If you would prefer to remain standing, I will give you that option. There are 2 matters that are before the court involving Mr. Arrington Copeland today, 26L000032 and 26L000304. Each of these 2 matters are before the court for pretrial conference. Mr. Larson, good morning. How would you like to proceed with the pretrial conferences?
Good morning, Your Honor, and for the record, Attorney Drew Larson here with Mr. Arrington Copeland, who is appearing via Zoom. Your Honor, parties wish to enter into a stipulated order of continuance today, and I've uploaded that to O Courts. Your Honor, I've reviewed the documents and collateral consequences with Mr. Arrington Copeland. Mr. Arrington Copeland understands that this is an agreement between him and the city. He understands that by entering into this agreement, he is giving up many important rights. Mr. Arrington Copeland understands.
Overstand. I don't stand under anybody.
Is that why he's not sitting in that chair?
Mr. Arrington Copeland understands that in order to benefit from this agreement, he must abide by certain conditions. Your Honor, this is a 24-month stipulated order of continuance. Pursuant to the stipulated order of continuance, Mr. Arrington Copeland is required to obtain a mental health evaluation and receive any recommended treatment under said evaluation. He's also to abide by the active protection order issued out of Pierce County Superior Court, and he is to have no new criminal law violations, Your Honor. Mr. Arrington Copeland understands that if he violates the terms of this agreement, the court can read the police report and find him guilty of the charged crime without trial. Mr. Arrington Copeland is stipulating to the admissibility and sufficiency of the facts in the police report to find him guilty. Mr. Arrington Copeland understands the maximum sentences that could be imposed on these charges if the agreement is revoked. Ultimately, Your Honor, I do believe that Mr. Arrington Copeland is entering into this agreement freely, knowingly, and voluntarily. Thank you.
Wait, he's consenting to a contract?
Thank you, Mr. Larson. Mr. Arrington Copeland, I show that your date of birth is December 3rd. Is that correct?
Indeed.
Mr. Arrington Copeland, I have in front of me a document entitled Stipulated Order of Continuance encompassing both of these cases. Have you reviewed this document in its entirety with your attorney?
Indeed.
Mr. Arrington Copeland, for all intents and purposes, this stipulated order of continuance is a contract that you're asking to enter into with the prosecution to resolve these two cases. Is that your understanding as well?
It was to my overstanding it's a stipulation or a contract that I was offered. I didn't ask for anything. I asked for a simple standby because I don't have any interest in dealing with this woman anymore. If it is all right, I'd like to address the court formally. Personally,
Mr. Arrington Copeland, what I'm trying to determine right now is whether or not you are asking to enter into this stipulated order of continuance agreement with the prosecution in these two cases. Is that how you're asking to proceed this morning?
indeed.
Yeah, Mr. Arrington Copeland, as we discussed, the protection order is issued out of a different court, and I've sent you an email with more information on how we can get that addressed, but this court is not the proper venue to address the underlying protection order.
Indeed.
Mr. Arrington Copeland, do you understand that?
I understand that you guys have to do your job. So yeah.
Well, and it's also important to me that you understand what Mr. Larson just said, which is there is a valid no contact order that has been issued in which you are the restrained party, but that was issued by Pierce County Superior Court because that's a different court. I don't have the authority to change or create any exceptions to that order. That's something you'd have to take up with that court.
I'm so glad he didn't say jurisdiction.
Okay.
That's fine. So I have a simple question. Upon release, if I go to Lakewood PD, can I have them take me there so that I can gather my things? Because I'm at this point, I have nothing. She left me with nothing. She has my identification in that location. I have no way.
Mr. Arrington Copeland, I've sent you an email with detailed instructions on how you can request a civil standby, but that has to be done through the Pierce County.
Larson, she has my EBT card. I have no way to feed myself. If that's the case, then I'll just stay in jail. I got 3 hots and a cot here.
Mr. Arrington Copeland, I've sent you an email. It'll be ready for you upon your release. That'll detail how you can get your wallet back, okay?
Well, for his sake, hopefully it's not thrown away.
And Your Honor, the city has had an opportunity to reach out to the victim. It's my understanding that his wallet is waiting for him at the Lakewood PD.
Oh, okay, that's very helpful. Thank you, Mr. Tuninga. So, Mr. Arrington Copeland, it sounds as if your wallet, which hopefully does contain your EBT card, has been taken and provided to the Lakewood Police Department. So you can swing by the Lakewood Police Department upon your release and pick that up.
Yeah,
Okay?
indeed.
So, Mr. Arrington Copeland, what I need to know is, and you answered this question a moment ago, that you understand that this is a contract between you and the prosecution, and that this is how you're asking to proceed today. Have you gone through this document in its entirety with Mr. Larson or one of his colleagues?
Indeed.
Okay. Have they answered all of your questions about the terms and conditions of this agreement?
Indeed. I only have one other question. What's the consequences, I guess?
We're going to get to that. We're going to go over that right now. But what I wanted to make sure of is that you've reviewed this document with your attorneys.
Indeed.
Okay. So, Mr. Arrington Copeland, by entering into this agreement, you are waiving a number of your constitutional rights, including your right to a speedy jury trial. Do you understand that?
Indeed.
Okay. It appears that this is an agreement for a period of 24 months or 2 years. If you fully comply with this agreement, after 2 years, the prosecution has agreed to file a motion to dismiss both of these cases. But in order for you to receive that benefit, you are agreeing to do a number of things over the next 2 years, and I want to review those conditions with you at this time. You are agreeing to appear on time for all scheduled court hearings. You are agreeing to have no violations of the criminal law. You are agreeing to keep the court updated as to what your best mailing address is. You are agreeing to obtain a mental health evaluation from a state certified agency such as Greater Lakes and file a copy of that evaluation with this court within the next 60 days. And then within the next 90 days, you are agreeing that you will be engaging in any counseling or treatment that evaluation recommends and will participate in and complete that treatment. And that proof will be filed with the court. Is that your understanding, Mr. Arrington Copeland, of what you have agreed to do in order to receive the benefit of this stipulated order of continuance agreement?
Yeah, under maritime law, yeah.
Could you say that last part again?
Under maritime law, yes.
Okay. But you understand that regardless of the body of law that is applied here, you understand what you're agreeing to do under this contract, correct?
Correct.
Okay. Now I want to talk to you about the next aspect of this. We've talked about what will happen if you fully comply with this agreement. Prosecutor will agree to dismiss both of these cases. Have you spoken with Mr. Larson, your attorney, about what would happen if at any time in the next 24 months, this court were to conclude that you had violated any aspect of this agreement or not fulfilled any of your obligations under this agreement?
Please review them with me.
Okay, but have you, the two of you, discussed
Yes,
what would happen?
we discussed briefly.
I'm sorry?
I want to hear from you though.
Say that again.
I said we discussed briefly, but I want to hear from you.
Okay, I'm going to go ahead and review that with you. So the bottom line is, if at any point in time in the next 24 months, the prosecutor were to bring a motion to revoke this agreement on the basis that you had not complied with any aspect of this agreement, the court would consider the evidence and determine if it is more likely than not that you have failed to comply with any condition or violated any condition of this agreement. If I concluded that it was more likely than not that you'd violated any aspect of this agreement, I would in all likelihood grant the prosecution's motion to revoke. Now, if that were to happen, the next thing this court would do is would conduct a bench trial to determine whether or not you are guilty or not guilty of 2 counts of domestic violence court order violation and 1 count of criminal trespass in the first degree domestic violence. It's very important that you understand, Mr. Arrington Copeland, all 3 of those charges are gross misdemeanor offenses. They are punishable by up to 364 days in jail and a $5,000 fine on each charge. And because they are crimes involving allegations that they are domestic violence related offenses, the court can take up to 5 years of jurisdiction if you're found guilty. The other part that you need to make sure you understand very clearly with this is if that were to happen, if this court were to revoke the agreement and proceed to a bench trial on these 3 charges, the only evidence the court's going to consider in determining whether or not you are guilty or not guilty is the police reports of the investigating police officers. And you are stipulating that that is admissible evidence and is the only evidence that I will consider at that bench trial. Do you understand all of that?
Indeed.
The overstand go out the window?
Okay. And this is still how you want to proceed with resolving both of these cases here today?
I have a question.
Go ahead.
So I need help overstanding something right now.
Overstanding is back.
How is a order filed out of Tacoma being prosecuted in Lakewood and upheld? That doesn't make sense to me.
Sure, that's a fair question. So remember that the court that issued the no contact order, that is the basis for 2 of these for the 3 criminal charges, that is a superior court of the state of Washington. Now that particular superior court is for Pierce County and it sits in downtown Tacoma. But they have jurisdiction as judicial officers in Superior Court over the entire state of Washington. Okay, so their orders are enforceable anywhere in the state of Washington, including the city of Lakewood. Further, it's also important, since you asked the question, remember that a Superior Court judge of a state in the state of Washington is their orders are entitled to what's called full faith and credit under the United States Constitution and also a federal law called the Violence Against Women's Act. Now, I point that out to you because I want to make sure you understand that order, you could be in Florida. And if you violated that order in Florida, you could be arrested and prosecuted by authorities in Florida because each and every state is required to give full faith and credit to the judicial orders of judges in other states. So this no contact order, as long as it remains valid, and you can always go back to the Superior Court and ask them to change it or cancel it, but as long as it remains valid, it is enforceable throughout the United States of America.
All right. My next question is, why am I taking this? Because he just told me that if I take this, then everything drops.
Everything is dropped if you hold up all of the terms and conditions of the agreement that you have agreed to. So after 24 months, if you've done everything that this agreement requires of you, the prosecutor has agreed their end of the bargain. They have agreed that if Mr. Arrington Copeland does everything he's agreed to, they will bring a motion to dismiss all 3 charges. And then everything will be dropped. But you've got things that you are required to do in order to receive that benefit, and it's going to have to take 2 years before the prosecutor does it.
Can the prosecution explain to me why I need to take a mental health evaluation?
I don't think the prosecution is going to explain anything here, Mr. Arrington Copeland. The way it works is the prosecutor speaks directly with your attorney who negotiates on your behalf. The prosecutor almost never speaks directly to individuals who are charged with a crime because he doesn't want to infringe upon your right to have an attorney represent you.
Indeed. All right, we're good.
Okay, do you have any other questions about this stipulated order of continuance agreement?
No, I'll talk to my lawyer about it.
I guess drop charges, drop the solvent citizen language.
Okay. So, Mr. Arrington Copeland, the last question I asked you that you still haven't answered, I asked if this is how you want to resolve all three of these charges with this agreement today. Is this how you want to proceed?
Indeed.
Okay. Mr. Larson, I have spoken with your client extensively, probably more than I do most defendants in a stipulated order of continuance. So I'm going to give you the last word here before the court makes a final determination. Mr. Larson, are you aware of any reason that this court should not accept entry of this stipulated order of continuance agreement as requested by your client?
No, Your Honor, and I would just note for the record that this was an extensively negotiated resolution here today between the defense and the prosecution. I have had extensive communications with Mr. Arrington Copeland regarding the stipulated order of continuance, and I am happily available to Mr. Arrington Copeland in the future should he have any questions regarding what he needs to be doing under this contract. I've already provided Mr. Arrington Copeland with an email dealing with sort of next steps on things that he needs to be doing upon his release as well, Your Honor.
And based upon your conversations with Mr. Arrington Copeland, you are satisfied that your client understands this agreement in its entirety, his obligations under this agreement, and the potential consequences he would face were he to be found in the next 2 years at any point to have violated this agreement?
I do believe he understands, Your Honor.
Okay. Based upon that record, the court is going to accept entry of the stipulated order of continuance agreement that has been negotiated between the parties in this matter. The court is satisfied, based on my conversation with Mr. Arrington Copeland this morning, that he understands the terms and conditions of this agreement and that he's entering into it knowingly, intelligently, and voluntarily. That is also bolstered by the two records that Mr. Larson has made regarding his communications with his client concerning the terms and conditions of this agreement. The court believes that Mr. Arrington Copeland understands the rights that he is waiving by entering into this agreement with the prosecution, the terms and conditions that he must satisfy in order to receive the benefit of this agreement, as well as the potential consequences that he would face and the procedure this court would follow in the event that the court were to conclude at any time during the next 24 months that he had not fully complied with this agreement. The court is setting a final review in this matter for February 17th, 2028 at 9 a.m. Court is going to waive Mr. Arrington Copeland's presence at that final review hearing if the parties are in agreement that he is in full compliance with all of the terms and conditions of this agreement prior to that hearing date. One question that I have for Mr. Tuanenga and for Mr. Larson, there is an affirmative condition as part of this stipulated order of continuance that we have discussed, the mental health evaluation and compliance with any recommended treatment. The parties have negotiated the evaluation to be filed with the court within 60 days and for any recommended treatment to commence within 90 days. Are the parties requesting an intervening hearing to review whether or not that condition is being complied with?
That would be city's request, Your Honor.
Defense would defer to the court on that issue, Your Honor.
I think that's appropriate. I'm going to ask one of the attorneys to load a notice of hearing. The court clerk is going to do that for me. The parties have negotiated a timeline for the evaluation of 60 days in compliance with recommended treatment within 90 days. So the court's inclination at this point is to set a review in approximately 120 days. The court's going to set that for July 9th, 2026 at 10 a.m. Court is going to waive Mr. Arrington Copeland's presence at that hearing if before that hearing the court has received documentation verifying that he has completed the mental health evaluation. And Mr. Larson, have you discussed with Mr. Arrington Copeland where he can go to get that mental health evaluation?
Yes, Your Honor. I've provided an email to Mr. Arrington Copeland detailing 3 or 4 locations in the Lakewood, Tacoma area where he can get that done.
Thank you. And then the court's also going to be looking for documentation verifying that Mr. Arrington Copeland has begun participating in complying with any treatment that's recommended in that evaluation. If the court has received documentation verifying compliance, and Mr. Arrington Copeland is otherwise in full compliance with all of the other terms and conditions, his presence at the hearing on July 9th is also waived. Otherwise, he will need to be here. Okay, that I believe will conclude Mr. Arrington Copeland's 2 hearings. Mr. Arrington Copeland, you should be released sometime in the next few hours. If you have any questions or you need any help following through and completing the terms of this agreement, please make sure that you reach out to your attorney so that they can advise you on how to proceed, okay?
Yeah.
All right, Mr. Arrington Copeland, you can let the officer know that your hearing is done. Thank you.
Indeed.
Well, it seems like he has a lot of contracts to fulfill. Let's see if he's able to keep up with it, because if he doesn't, we'll see him in court again. So I hope you enjoyed both videos. Give it a thumbs up if you did. Leave a comment, and I'll see you around on the next one.
Morning in court, camera on the screen. Judge asks his name like it's always been. He pauses a moment, then flips the scene. True name, or the name you have on file for me. Room goes quiet, lawyer takes a breath. Judge keeps steady, calm in the test. Trying to move the hearing along the way, but the answers come different than most would say. I don't understand, I overstand, he said. Words turning slow inside his head. Courtroom rules and what they read. Every answer coming back indeed. Judge explains the terms one line at a time. 2 years straight and the charges decline. Writes on the table contract to read. He listens, quiet answers indeed. Questions rise about the law in place. Why one